attendees are in listen-only mode.
Welcome everyone to the fourth of our webinar series. My name is Jean Brueggemann. I'm the Executive Director of the Freedom Network USA. We are a coalition of service providers and individuals across the United States working directly with trafficking survivors and advocating on their behalf. And we are bringing to you this webinar series with the support of the Office for Victims of Crime, the Department of Justice, and OVCTTAC to bring more information about trauma-informed case management for those of you working with trafficking survivors. And I'm going to turn it over now to our own Amy Fleischhauer.
Hi everyone, this is Amy Fleischhauer, a member of Freedom Network, and I work at the International Institute of Buffalo, and I'll be facilitating today's webinar. Before I introduce our speakers, I wanted to just review how our webinar series works. This, as Jean mentioned, is the fourth area of content on trauma-informed case management. Today we'll be focused on referrals and consents to release information. These webinars have been building on one another, and today we will be content focused, so our speakers will be doing more of a lecture, and then in 2 weeks we'll follow up with a live chat where our speakers will be able to specifically address any questions or delve more deeply into areas of the presentation that our participants are interested in. But for today, I would just encourage people to please participate in a couple of ways. The first is that there will be several polls throughout today's webinar, and we'll ask everyone to participate in those. And in addition, if there's any questions that anyone has, just to clarify quickly any of the content. So for instance, if the speakers make mention of something that's perhaps specific to their state or an acronym, or you didn't hear them, you can ask that question in either the question or chat box, and I will interrupt and be able to ask for that clarification. But if you're looking for any information, like I said before, to delve more deeply into the content, then please do use the question or chat box to ask those questions, but we'll save them for the live chat in 2 weeks. So with that, I'd like to introduce our speakers, Darcy Flynn from Heartland Human Care Services and Catherine Wagemer from Metropolitan Family Services.
Great, thanks so much, Amy. This is Darcy, and I'm here actually in the same spot as Catherine. So we first wanted to just give you an overview of the agencies that we each respectively work for. So I work for Heartland Human Care Services, which is a company of Heartland Alliance located in Chicago, Illinois. We are the leading anti-poverty organization in the Midwest. We're very large. We have over 1,200 programs, or 100 programs, 1,200 staff, sorry. And we are in multiple Midwest cities, multiple states, as well as multiple countries. So we have a large scope, and of course anti-trafficking work fits right into that. So on the next slide you'll see the Trafficking Victims Assistance Program, which is the program that I work on at Heartland Alliance. We help to co-administer the Trafficking Victims Assistance Program with USCRI, the U.S. Committee for Refugees and Immigrants, located in Washington, D.C. So my role is to oversee that program in multiple states. We cover 32 states collectively, and I oversee about 16 of those states, working with service providers, providing technical assistance and capacity development. And then I also supervise the direct services out of Heartland, serving the foreign national survivors that we serve here in the Chicagoland area. So that's kind of the context or content of why I've been asked to speak today about confidentiality and consents and releases and all of that.
Thanks. I'm Catherine Monkmer, and I am with the Legal Aid Society of Metropolitan Family Services. And Metropolitan is also a very large social service agency that serves the city of Chicago and the surrounding area. We have nearly 900 employees And we operate out of 7 community centers for most of our service programs. And then we also have the Legal Aid Society. And underneath the Legal Aid Society, we have 2 programs, the Human Trafficking Initiative and the Victim Legal Assistance Network. And with those, so I oversee the Human Trafficking Initiative and I supervise the attorneys in the Victim Legal Assistance Network. As part of those programs, we provide holistic legal services to survivors of crime, including survivors of human trafficking. And so that's the focus, and that's why I was asked to present and speak today.
And before we dive into the content, just a review and to reiterate that there's a lot of literature out there on trauma-informed care. This webinar series is really getting at the surface level and starting a dialogue about what trauma-informed case management looks like. And so what we did was try to review the research and create consistent principles that we could use to guide this webinar series. And so this is just a reminder of what those principles are, which you've seen over the past 3 other webinars that were part of this series. The objectives today are to understand what the best practices are regarding confidentiality and making referrals for the survivors that we work with. We have provided you with some sample tools to use with clients in terms of releases of information and confidentiality. You can find that in the handout section of your webinar box. You can download those and those are readily available for you. And then we also, of course, want to talk about throughout this whole webinar what confidentiality looks like through a trauma-informed lens.
So before we dive in, first we need to really understand confidentiality and privilege. And this is a helpful image to understand that there's a lot of information that is confidential, and some of that information may also be privileged. So what's the difference between the two? You can move to the next slide. So confidentiality is a practice. It's an ethical duty that refers to treating information as private. It covers a broad array of information. It can be a client's name, that you're working with that individual, where they live, anything about why they're seeking your services. It can cover a lot, and it can cover a lot of different professional groups. Privilege, however, is an evidentiary rule, and so it is very limited into the types of information that is covered and who is covered for this purposes. So confidentiality, let's dive into that a little bit more. All victims of crime have a right to confidentiality. A victim, when they come to you, they're going to have to disclose information that can be really hard for them to talk about. And it's important that they know that you're going to do your best to keep that information private, that you have a duty in order to protect their information so that they can feel comfortable sharing what they need to in order to receive your services. Privilege, however, the purpose of that is to avoid someone from having to answer questions in a judicial proceeding. So for example, attorney-client privilege protects the attorney and also the client from having to discuss what is disclosed in communications between the attorney and the client. If you break this privilege, so let's say you as the caseworker approach your client and ask your client, what did you discuss with your attorney, you're going to end up waiving that privilege, and we don't want to do that. And so it's important to sort of understand which information is privileged, what's protected, and how to protect it. So again, it's a legal protection, and it varies depending on your jurisdiction. So if you are in federal court versus state court, attorney-client privilege exists in both federal and state court. But in your state, you may have privilege protections depending on if you are a caseworker, a mental health worker, a domestic violence worker, that may not exists in federal court and it may not exist in other states. And so it's important to understand what venue you're in and what the jurisdiction is in order for you to know whether or not that information is covered by privilege. The other important part about privilege is how does third-party presence intersect with confidentiality and privilege. So again, because confidentiality is an ethical duty and it's very broad, the presence of a third party doesn't impact your ethical requirement to keep clients' information confidential. However, the presence of a third party can impact whether or not information remains privileged. If you need that third party to be in the room in order to execute services, for instance, an interpreter, if I need to be able to communicate with my client in another language, I can have a third party in the room, and in no way is the privilege compromised by having that individual with me. However, let's say my client comes in and wants their caseworker in the room with me, or a family member or supportive person. If they remain in the room while I'm talking with the client or the client's discussing what happened with me, that information is no longer privileged. That entire meeting is information that I can be required to testify to in court, that the client can be required to testify in the third party. And so that's why it's vital and why it can be important for caseworkers to understand this, so that when a client is being referred to an attorney, that you're not offended when the attorney asks you to leave the room, but also so that you can properly prepare your client that, well, it's perfectly all right and important that you're there to support them and to accompany them to those meetings. It's also important that you know what you want the client to discuss with you after those meetings. So absolutely, it's okay to discuss with the attorney logistics. It's okay to discuss with your client after those meetings how they're feeling, but you never want to ask the client what their attorney told them. You don't want to discuss the communications that occurred and risk waiving that privilege.
So now we have our first poll question. In my role, I am a mandated reporter, and then we want you to select one, yes, no, or I don't know. We'll give you a few seconds to complete that. All right, so it looks like 75% of you say that you are a mandated reporter and 25% say you aren't, and no one doesn't know, which that is great. That's great that you know whether you are or you are not. And as Catherine said, every state has different laws on who is covered by mandated reporting and privilege and all of that. So if you're thinking, I don't know if I'm covered by privilege, I just, again, encourage you to go back to maybe your supervisor or your team and talk about what that looks like at in your own respective communities. But because most of us, 75% here on the call, are mandated reporters, we wanted to talk with you about what it means to be a mandated reporter and to make a report in a trauma-informed way. So, of course, if something happens, if your client reports child abuse or that they're going to hurt themselves or someone else, of course that kind of inflicts the mandated reporting. It engages that need to make a mandated report. But that doesn't mean you just leave the room and go call your child welfare services or law enforcement. There are ways to do it in a trauma-informed way. So the first that we always like to talk about here at Heartland is spread the risk. Tell your supervisor, right? Talk through with someone at your agency, your supervisor or your director of your program, about what has been disclosed and why you feel like you have to make a mandated report, because then all of that pressure doesn't just fall on your shoulders. Discuss with the client about why you have to report, and again, you should be discussing this at the beginning when you talk about confidentiality, when you first meet your client, so you can say Remember when we first met and we talked about anything you tell me is confidential unless you tell me you're going to hurt yourself or someone else, or you have hurt someone else, especially a child. You can kind of refer back to that to remind them, and then talk to them about who you're going to have to report to. And it will depend, right? It could be law enforcement, it could be child welfare. It really depends on the situation and who it is in your community that you're mandated to report to. And then validate that it's scary, right? They're going to be upset. They're going to be maybe angry. They're going to be scared. In our world, we work a lot with foreign national survivors of trafficking who are sometimes undocumented. So that adds another level of scariness. So validate that, remain on their side, right? They're not necessarily in trouble with you. It's not going to necessarily impact your relationship with them in a negative way. And then if you can, call together, right? Call DCFS together or call law enforcement together. You don't have to be the one exiting the room and making this kind of private, scary phone call all on your own. If child welfare or law enforcement is going to report to their home, or maybe they'll come directly to your office, you know, be present when they arrive, if possible. And then, of course, if there's an attorney involved in the client's case, I would also recommend calling the attorney as a side-by-side to this mandated reporting, especially if law enforcement is going to be the one responding. And I think number 8 is, you know, shuffled in all of these, but it's so important to just continue to support that client through all of these steps. And then as a case manager or as an advocate, to, after the fact, process with your team and your supervisor, because it's not going to feel great on your end. And perhaps there are things that, looking back, you're going to say, I wish I did that differently. So process that as a team, because it's probably not the last time you're going to have to make a mandated report. So now we want to talk about the consent to release information. We're going to try to break it down into when, why, what, and how in the context of consent to release.
Right, so when do you need to use a consent to release? And we can move to the next slide. Anytime you need to request confidential information, so again, what we covered earlier, if it's in that broad circle, if it's confidential, maybe privileged, but definitely confidential, you need to get your client's permission in order to make that request and allow the other agency or the party to release that information to you.
Also, in a case management setting, you might have a client who has 3 case managers across 3 different agencies. So you might have to request from other case managers, or those case managers might be requesting of you what you're working on, what's going on with the client in the context of your services. But a release is still needed, even though all of these people are, of course, on the survivor's side and on their team. There still needs to be a release among all the people providing services to that client. So often you might get a call and say, hi, I'm calling to see if you're working with Jane Smith. And if you don't have a release to talk to that person that's on the other end of the phone call, all you can say in order to maintain your confidentiality is, I cannot confirm or deny if I'm working with this person, right? Which this has come up throughout this webinar series. If this is not your first time having a training on confidentiality, this saying is really common, but it's a great way to really not break confidentiality.
And if you are the one making the referral on behalf of your client, you're also going to need to use it. So if I need to go and refer to Darcy, even for me to say, look, I want to give you my client's name and I want to give you their phone number and I'd like to enroll them in your program, in order to make that referral, even if it's to another party or to another program within your own agency, you have to do that. And you'll see in our list of documents, we have some sample consent to release information, and we have a sample referral that includes the referral that we use within our own agencies to refer to outside organizations and internally.
Catherine and Darcy, this is Amy. I just wanted to ask to underscore this point also with perhaps some phrasing on, we will often get somebody who calls and says the client's name, like, hi, I'm calling about a trafficking survivor, her name is, and we find ourselves like literally interrupting and saying, whoa, 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 I'm sorry, do you have a consent? Are you sure you have a consent? Is that something that you've experienced, and would you find that to be appropriate?
Absolutely. If you're getting phone calls, I get calls all the time where people want to run quote-unquote hypotheticals by me. Is this trafficking? And then they start to disclose confidential information, and I stop them there to say we can talk hypothetically, but if you don't have a consent form to tell me your client's name or where they were trafficked or the name of their trafficker, please do not share that with me, because you don't have consent to do so. Absolutely.
Thanks.
Okay, so now the why and what. So when you're going over a release of information, so picture your own agency's release of information, it's really important to not just brush over it, write the client's name on it and say, sign this, it's so I can talk to your attorney, and then kind of move on to the next thing in your meeting. It's really important to talk about what that release means and why the third party needs to speak with you, or why you need to speak with that third party, whether it's a mental health provider, a food pantry, an attorney, it doesn't matter, it's still a third party. And then really talk with your client about what information needs to be shared or will be shared. Is it just demographics? Do you just need to call and say, my client, Jane Smith, needs to see a therapist? Here's her phone number, can you call and make an appointment? That's what you can share, because that's what you've discussed with your client. It's also really important to ask your client what they don't feel comfortable sharing. So Catherine and I, so Catherine the attorney, myself being a social worker case manager, we share mutual clients. Just because I have a release to talk to Catherine doesn't mean I can tell her anything I feel like that day, right? It's what my client has said is okay to share, and if my client has said you cannot share X, then I cannot share X with Catherine. Perhaps I can talk about why that information is important for their attorney to know. You can give some education around that. But if my client tells me I can't share something and it doesn't enact mandated reporting, then I have to keep that information confidential.
Let's talk about exactly how do you do a release of information. And the first thing I want to emphasize is it is vital that if you have a client who does not read English, that you translate the form into a language that they understand. And you have to think through how many of these clients ended up in their trafficking situation because they were presented with documents by someone they trusted, often an authority, and they said, here's what this document says, sign this. And they couldn't read the document, they couldn't keep a copy of it. And so it's really important that we change those dynamics, and that when we are giving the client something to sign, that they have a copy that goes back with them, that they can read, that they can review, that they can understand exactly what they signed. And if they decide later, after they've reviewed this document again, that maybe they've changed their mind down the road, and they want to be able to have that document say, oh, here's exactly how I can revoke a release, which we'll talk about a little bit later. But I can't express how important it is to make sure it's translated. I also will understand that sometimes there are cases that come up really quickly, and it's a language that you don't already have your form translated. At the minimum, if you have to, you read line by line and have it verbally translated. And then the best practice would be to get that document translated and send them a copy of what they signed. It's also really important that in your, that in your release of information, that you are as specific and as limited in the information as possible. And again, this goes back to making sure you aren't waiving privilege. If there's information that potentially is privileged, you don't want to start sharing it across the board. You don't want to have someone be able, an attorney come to you and say, I'm going to subpoena your records, and I see you disclosed and you talked to this person, you talked to this person, and you have permission to share your entire case file with this other party. You don't want to have more people involved, and even if you're not planning to share that broadly, don't write your release that broadly. Write it as narrow and specific as possible, and if you need to do additional releases of information, do those later on, but keep it specific and narrow. And then it's really important to talk to your client about what are the consequences of not signing this release of information. sometimes for me, if a client doesn't sign a release of information, it means I can't proceed on their case, that I need a document, and if they won't sign that over, then I can't handle their legal case. But other times, it's simply a referral, to case management services. And if they don't want to sign it, nothing happens. It's completely voluntary. There's no consequences for my services on whether or not they sign it. And so it's really important to explain to the client and let them know, what are the consequences if you choose not to sign it. And I'd encourage that that's actually included in your release of information. You'll see that is in one of our releases of information that we use in one of our samples that the attorneys use at Metropolitan Family Services. And then it's also important that you're using the correct release of information. So if you are requesting medical records, you need different types of releases signed than if you're just simply requesting release of information to give over someone's name and phone number to make a referral. And so it's important to know and have an appropriate document signed to protect yourself and to protect your client. And then make sure you include and talk to the client about how long does this release need to be for. In Illinois, releases are valid for 1 year. You can't sign them for longer than that, but you definitely can sign them for a shorter period of time. And it's important to talk to your client about how long do they want this to be valid. Maybe they only want it to be valid for 1 week, so you can make the referral, and then they don't want you to be able to continue to communicate, and that's valid.
And then also, as a case manager, really think about, do you need 15 releases of information, or is it time to talk to your client about can they share the information, right? From an empowerment standpoint, sometimes it's easy to get into this habit of, oh, I'll just be the one to communicate with your attorney. I'll just be the one to communicate with public benefits or whatever the third party is. But the client is also capable and has the wherewithal to share their own information, right? And so sometimes they just think you have to because you're their case manager, but I think it's really important to have those conversations of, do you feel comfortable calling public benefits and asking this, or sharing that you, changed your job or moved addresses? And if they say yes, then walk them through how to do that, but you don't need a release at that point because they're the one sharing that information directly. So there's a way to also be trauma-informed and empowering the clients without even inflicting a release of information, right? So we just wanted to draw that to your attention as well.
So the next thing to consider when you're doing these referrals and these releases of information is, what are the cultural considerations when you're talking with your client? And the first thing is the right to refuse. So it's easy for us to say to the client, you don't have to sign this is your choice. But it's also important for you to sort of step back, and you are in a position of authority, and there are certain cultures where they don't feel like they actually have the right to refuse you. And so it's important to take your training that you have in cultural sensitivity and thinking through, how are you phrasing these requests? How are you asking them about what this means, and giving them a real opportunity that they feel that they can say no. It's also important to look at if you're asking or requesting sensitive information. So maybe I'm trying to get medical records for a client, or they're just concerned about their attorney and their caseworker being able to talk to each other. It's important to look through how has their information been shared in the past, either in their trafficking situation or before they were in their trafficking situation, that can impact how comfortable they feel with these releases of information and these signed documents. And again, if you've got a client where information's been used to shame and control them, it's really hard for them to feel comfortable signing these. And so it's important, again, to make them narrow and to discuss with the client the purposes of the release and empowering them of alternative ways to do it to share that information. But sometimes you have clients, that you can move to the next slide, that look at you as an authority figure, and they come in and they say, I'm comfortable with you sharing my information with anyone and everyone. And I've had this with clients more often than not, as they look at you as, I will trust you with whatever you want to do. So it's okay for you to share. And even in those cases, and especially in those cases, it's really important that every time you need them to sign a release of information or make a referral, that you really go through this process and you go through empowering them to make their own decision about whether or not they feel comfortable moving forward with that release, instead of just falling back into this, well, you're my attorney, you're my caseworker, whatever you think is best, I will do. Because I can't tell you how many clients we have that will say that to us. And it's easy to sort of say, oh, this is just easier, right? It's easier for me to have them sign this release, not explain it, send it to Darcy, send it to another referral, have those conversations myself, and it might feel much more efficient. But that's not best practice, that's not empowering, and that's certainly not a trauma-informed approach.
So earlier we started to talk about that right to refuse and right to revoke, which we've talked about, and we're going to jump into another case study in just a moment. But we just wanted to reiterate that just telling your client you have a right to not sign this, you have a right to call me one day and say, never mind, I don't want that release. First of all, clients aren't even probably going to remember that you signed a release with them, right? They have a lot going on in their life. So oftentimes, right, it's a best practice to actually sit down with your case file maybe once a month with your client to go through all of your releases to say, hey, is it still okay if I'm communicating with your attorney or with public benefits, or whoever it is that you have the release with? And that's giving them a tangible opportunity to say, actually, you know what, I don't want you to talk with them anymore, or actually, you know what, I'm not seeing my therapist anymore, so we don't even have a relationship. So that's a really important way or good way to have these conversations in a concrete way, and to reiterate that they can change their mind, and then what happens next if they have either refused or revoked, which we talked about. And again, just because you have a release with someone, that release tells, or should tell if you've completed it correctly, what you can share. So just because I have a release with Catherine doesn't mean I can just call Catherine all the time and talk to her about my clients. If I need to call Catherine and talk to her about my client about, you know, topic X, I'm going to call my client and say, hey, we have this release with your attorney. Is it okay if I share this with her? Remember we talked about that yesterday, or whatever it is. To really have those concrete conversations about each time you're going to talk to that third party. It's also a great way to build trust with survivors because you're being really transparent about what's being shared, when it's being shared, and why it's being shared. So the next case study is a mutual case that Catherine and I had that we're going to call SQ. I always say this case taught me everything I know as a social worker. It was a very complex case, but just to kind of, we want to hone in on, of course, the relevant pieces to this topic today. So to give you a little bit of background, this client was identified in a medical setting, and there was a lot of unknowns about her. We didn't know her legal name, her actual age. There was a lot of unknowns about who she was, where she came from, what she needed, what she had experienced. So as a case manager, we were really starting from scratch. And she had, because, of course, of her significant trauma history and the exploitation she had experienced, she had a lot of issues with trust and sharing information. And so it was a whole lot of rapport building for a very long time to even get to the point where she was willing to share with us, let alone a third party outside of our agency. When we met her, she had an attorney, but since fired that attorney, and that's why we were able to bring in Metropolitan on the case, because she wanted to try a new attorney. But this is a perfect example of when we made that referral to Metropolitan, she signed the release so that we could make the referral, and then the only thing we were allowed to share was we're working with her and she wants legal services, and then she revokes that release of information. So once she became Catherine's client, we couldn't really talk to each other. And then she would reinstate a release of information about very specific things. Then she would revoke it. Then she would reinstate it again about different specific things. So there was a lot of back and forth with those releases of information, but that was okay because she was in charge of that information. And in that case, what we learned over time from a case management standpoint, and then I'll let Catherine talk about kind of the legal stuff, was that it was really less about the releases of information because it was really difficult for her to share information and have other people sharing her information. It was more about empowering her to share her own information when she was comfortable, when she was ready, and with whom she wanted to share it. So it became less about, I need to share this with your doctor, your therapist, your other case manager, and more about, you, if you want to share this information, here's how you can share it and here's who you can share it with, sort of thing. Because releases of information was really triggering for her, and we learned that very quickly, and we learned to adapt to it, right? Because, you know, case management doesn't have to be rigid, because if it is rigid, it's not trauma-informed necessarily. So I'll let Catherine talk a little bit more about what those releases of information look like as well.
Yeah, so with this client, we experienced, in some ways, she was very willing to let us do releases of information for anything we needed for her legal case. So we were able to gather and collect a lot of information that the client hadn't had before, and information that was floating around about her in medical records, so that we could then hand over to her this information that she knew existed but hadn't seen and didn't have control over. So we were, in some ways, didn't experience this back and forth of releasing and revoking. Where it impacted us from a legal standpoint is when she was working with other agencies that were involved in her case, where she would, it was well known that we were representing her. It wasn't a confidentiality issue. It was known that we were her attorneys, that they would contact us and be very upset at the fact that she refused to sign this release of information. And they felt that it was important for us as her attorney to essentially convince her to make us share the information we gathered with them. And I can't tell you how shocking it is to have some of those conversations with other service providers and other attorneys and explain to them their own, you know, ethical duties that exist within the bounds of our professions, that no, in fact, it is not my role as her attorney to get her to sign documents, that she gets to control her information and she gets to decide what to do with the information. And so I think you have to be willing. You sometimes may encounter other agencies that you trust, that you partner with, who may get really upset if you have a client that's not as willing to share as you're accustomed to, and trying to figure out ways to work around that and to continue to, you know, advocate on behalf of your client, because your client is what matters. Your loyalty is to your client, is not to the relationships that your agency has with another agency. And even if protecting your client's information means that relationship may be damaged, you still have to protect the client's information and respect their rights.
And in this case, SQ, from a case management standpoint, was in a lot of ways testing boundaries, right? Because her boundaries and her relationships with people who she trusted at one point in her life had been really damaged. And so she was testing me as her case manager on how I was going to handle her information, because her information was her sacred, private thing, right? And she was really testing me to see, ultimately, right, I don't know that she would describe it this way, but she was testing me to see if I was going to break confidentiality and break her trust. And as a case manager, it was my ultimate goal to not do that, of course, because of my own ethical duties of confidentiality, but also we know that that's not a trauma-informed way to serve survivors, and we know that information and how they think their information is being shared is so sensitive that it's really up to us to protect that, even if they're pushing our boundaries and they're pressing buttons. And right, it's easy to get frustrated in those moments, because in a lot of ways I couldn't move forward, I couldn't make referrals, I couldn't call shelters because I couldn't tell them anything about her because she didn't want me to. But those were just honest conversations I had with her, and again, went back and empowered her to make the phone calls to shelters, and what she ultimately ended up doing. So it takes some patience in these situations, but as you've learned throughout this webinar series, patience and trauma-informed care really go hand in hand. So this case, again, we could talk about this case for a whole webinar series, but we wanted to just hone in on the pieces of confidentiality that were relevant here.
So moving on, let's talk about making those referrals and a couple of ways that those referrals can be handled. And one approach is that we call at our agency the warm handoff approach. And this is what we consider to be best practice if you are making a referral to someone else that is within your same city or geographic region that you can reach. And the purpose of that is you physically accompany your client to the person that you were referring to, and then you both are there sort of in that introductory meeting with them before anything confidential or privileged is discussed. You make sure your client is comfortable, and then you exit the room at the point that confidential information that you don't need to know, that you're not privy to, starts to be discussed. And one of the ways that we do it, and this is, I realize if you're looking at this slide, during what do you mean you're making a referral without a release of information? You guys just spent the last 40 minutes talking about how important that is. But there are ways to do this, and we do this with our clients here. And what that can look like is, for example, when I have a client that maybe has just gotten their T visa and they're now eligible to enroll in a program that they weren't before. And because that can happen quickly, and my clients often live outside of this city, I don't want to bring them into a meeting to simply sign a release of information, get their T visa, and then have to wait several weeks before they get that referral. I want them to be enrolled in services as soon as possible. And so what I'll do is I'll have a conversation with them, and I'll say, now that you have your T visa, you're eligible for this program. And I will explain the program, and I will say, often what I do, and you can choose to do this or not, is we can invite someone from that program to come to my office, and after we're done meeting and I've given you your T visa and we've discussed what it is, you can be introduced to them and you can enroll in their program, and we can talk about what it looks like. And more often than not, my clients say, that's great, yes, set that up. And what I do then is I call Darcy, or I call the service provider that I'm making the referral to, and I say, are you available to come to my office at this time, because I have a referral for you? And I don't give her any information about the referral. I don't give her the name of the client. I don't give her the gender of the client. I don't give her anything other than they're eligible for your program. Here's the date and time and the location of the meeting. And then at that point, I haven't violated anything. I haven't released any confidential information, and yet it allows the client to go forward with services without this delay in trying to get these releases of information. And then at the meeting, if there is reason that Darcy and I, or the service provider and I, would need to continue to communicate, at that meeting we have releases of information that the client signs for us to be allowed to communicate moving forward.
And then from my standpoint, because I oversee a multi-state program, we often get referrals from an attorney in South Dakota, for example. And they say, I have a client that's been identified as a trafficking survivor. Can I refer them for services? And so instead of me getting a whole lot of confidential information about this client, who as a program officer of this program I don't need, right? I just connect the referral source, which oftentimes is an attorney, to the case manager in South Dakota, and make sure releases are signed at that point so that the attorney can share directly with the case manager that will be taking the case. And I can be there to support for technical assistance and questions that may come up, but I don't need to know the client's name. I don't need to know the details of their trafficking situation. I don't need to know anything other than an attorney has done a screening, they're eligible for our program, and they're in South Dakota. I do need the city that they're in to find a service provider, but that's about it. So we really try to protect that information, and when we're doing that handoff, reiterating a release has to be signed before future conversations can happen. So we make sure that's happening across the country as well underneath the TVAP program. And then as we discussed with the SQ case study, information sharing after referral is made, it goes back to what did you say you would share, and it goes back to giving your client permission to revoke that release after the referral is made. As case managers, you're often going to be making referrals to other community organizations, other service providers, and so it's totally okay to call around and say, I'm working with an adult female who needs a medical provider and she doesn't have health insurance. I haven't disclosed anything about who my client is. I'm just asking specifics about who they can serve, right? So that's okay. But when you're going to make that formal referral and share demographic information or perhaps broadly what their medical needs are, you know, they need to see an OBGYN or they need to see a physical therapist or whatever it is, you need that release of information at that point, or you need to empower your client to call the doctor once you realize the doctor can take them in as a patient. Again, what does that community organization need to know? I don't need to call and say, my client's an adult female with 2 children, she's undocumented, she's pursuing a T visa, and she's a victim of labor trafficking. I don't need to do that if my client needs food at the food pantry, right? They don't need to know that. They need that to know she's hungry and she lives in the jurisdiction that the food pantry serves. And again, it always comes back to what that client is comfortable sharing, and that may be different. The client may be more comfortable sharing with their therapist than their attorney, or with their another case manager, another service provider versus their therapist, or whatever. So it really comes down to each individual relationship that you're having a release of information with. So there are very easy ways, small ways, and kind of, I guess, easy ways that we can inadvertently break confidentiality that perhaps we're not even thinking about. So I wanted to bring a couple of these up that I learned early on that I became aware of. So your signature in your email. Does your email say you're a human trafficking specialist? Because if it does and you just emailed a third party who your client said, don't tell them I'm a victim of trafficking, you probably just broke that confidentiality because your title insinuates that you work with survivors of trafficking. Same thing with your voicemail. Our program is the Freedom from Trafficking program, but my voicemail doesn't say this is Darcy Flynn from the Freedom from Trafficking program. It says Heartland Human Care Services. What does your business card say? And in a lot of instances, the fact that they're a trafficking victim is what's connecting you, right? The only reason I would talk to Catherine, she only works with victims of trafficking, I only work with victims of trafficking, it's implied. But my client's landlord doesn't need to know I only work with victims of trafficking, right? They don't need to know that my client's a victim of trafficking. So there's a lot of different professions or kind of disciplines that really don't need to know, and you can really avoid these kind of mistakes in breaking confidentiality. So a couple that came to mind when I was preparing this are landlords, therapists. Whenever we make a referral to therapists, there are some therapists who just know us because ultimately they know the work that we do, but we always just say, you know, they need mental health services, they've experienced trauma, and we leave it at that. We don't say more because it's up to the client to share about their trauma and what that exactly looks like and is defined by them on their terms. It's not up to me to tell a therapist about their trafficking situation, and ultimately I don't know a lot about their trafficking situation as their case manager. English classes. Their English teacher and the students in that English class do not need to know they're a victim of trafficking, and so how are you communicating when you make that referral, and are you disclosing it inadvertently? And then daycare as well, child care providers are big ones that came up that they really don't need to know that the client's a victim of trafficking, and especially if the client has said, don't tell them that I'm a victim of trafficking. These are ways that you want to protect yourself.
Let's switch gears a little bit and think about when you use interpreters and how do you do that in a safe and a trauma-informed way that also protects your client's confidentiality. So one, I can't emphasize how important it is to make sure your interpreter is safe. And it's easy to think that, oh, they're in a certain profession or they're with a certain organization, of course they're going to be safe. And the reality that we have found is that these communities with some of these languages can be really small. And even if you're going from, we have We had a client that we knew their trafficking situation was in another part of the country. They had relocated here. We had made an effort because we really wanted to do an in-person interpretation for the client, and we knew the community was small, and so when we were reaching out, we did all the work to get all the information we could about the interpreter and relayed that to the client without using an interpreter or with using a different interpreter from another party that didn't share any of the client's information, to find out if the client was comfortable using that individual. And what we found is that the client was pretty certain the interpreter likely knew her trafficker, even though many, many states away. And so what we ended up doing is we ended up actually using and engaging an interpreter that was out of country. And then we made a point to talk with the service that we were using and to get them to move from their guidelines of, we won't let you request the same interpreter. That's not our policy, of saying we have an extremely sensitive situation. We need to use this interpreter. We've had safety issues with using others that it has to be this one individual. And so we've gotten them to simply change their guidelines. But it's important to think through and to advocate when and how you can in order to make sure it's safe. It's also important that if you do have documents, let's say you're getting a release of information translated, you don't need to include anything about the client on that release of information. Redact information that you can and then are able to add back later. So we've done that with birth certificates and with other documents when we've had situations where we're really concerned that the interpretation community is so small that somehow this could get connected to the trafficker, even though they all are supposed to be covered and have ethical guidelines of confidentiality. The other instance where Darcy and I have seen this come up is with interpreters that the client themselves had identified as a safe interpreter. And so it was a situation, it came in very quickly. It came from law enforcement. I got a call and needed to go out to another community that day. My program had just started. We did not have a formal interpretation line set up because my agency had never before worked with clients that weren't Spanish, English, or Polish speaking, and so we didn't have those resources available. And I think I had been there for like a month. And so this client said, oh, there's a member of my legal team on another case that I am working with, and that's a safe person. And I have to tell you, as a lawyer, I am inclined to trust members of my profession and their staff. And we thought that, you know, this is someone the client said was safe. This is someone that seems like they should be safe. They're working in a profession. And as I continued to work with this client, and we had other interpreters, we weren't using this person except for a very initial first day thing. There wasn't confidential information that was passed, but it led the client to continue to stay in touch with this individual that we later believe was actually likely involved in the client's trafficking, and then was giving information that was directly against the legal advice we were giving her. And it's really hard to build trust and rapport when you have someone that contradicts everything you say and that the client very clearly trusts. So it just is really on you to make sure you know your interpreters, you know that they're safe, and that you don't rely on family members or individuals in another profession and just assume that, of course, they're going to be safe. So continuing with this, there are laws that require a number of individuals and agencies to have and provide interpretation services. And so hopefully, if you are covered by this, if your agency is covered by this, you already have an interpretation service in place. If not, that's going to be your homework to do and to advocate for that. But it's also a key tool for you to be aware of. And we're not going to go into detail. These are complex. There are a lot of ways of how these laws work, but we want you to know that if you run into a service provider referral and they're saying, no, we only provide English, Spanish, and your client doesn't speak either of those languages, that there's a good chance that if they receive any type of federal funding, or it falls under the Americans with Disability Act, or it's a duty of their profession, that they just have to go ahead and pay for an interpreter and make that arrangement.
And in our instances, even though the law says they have to, so oftentimes there's no funding for it. So as case managers, it's all about continuous advocacy, citing the law, reminding them that Spanish isn't the only non-English language, and then calling ahead, if possible, to confirm that an interpreter will be available if it's a doctor's appointment or going to the public benefits office or whatever it is, to have that readily available. So our final, or no, third to last, or second to last poll question. My agency has funds available to pay for over-the-phone interpretation and or in-person interpretation. So either yes, no, or I don't know. Okay, so this is great. 71% of your agencies say that you do have funds available to pay for interpretation, and only 29% say that you don't. So that's great. I think I was actually surprised. I was thinking that was going to be smaller, just based on I constantly hear we don't have funds for interpretation, because it is hard to get funders to support something like that. So who's responsible for finding interpreters? This is, if you notice a trend, meeting with an attorney, it's up to the attorney. Meeting with a case manager, it's up to the case manager. This caveat for meeting with law enforcement, we often get calls that law enforcement is about to conduct a raid or an operation, and they're asking us to provide the interpreter because they know they're going to be French speaking or Mandarin speaking or whatever it is, and we say that's not our role. We cannot provide interpreters for that operation or that raid. We can be available for supportive services after the fact if survivors want to engage in that type of service. Okay, so just quickly, I think there's a lot of kind of defined professions, right, that we've talked about: mental health, medical, legal, case managers, but then there's just the community members or friends of the survivor or the client. And those individuals may call you and want check-ins about what's going on, or why is the T visa taking so long, or my friend isn't feeling supported. But you still need a release of information, even though it's not an agency or a social worker or an attorney. You can still and should still have a release of information with that friend or community member that is wanting to engage in services, and it's up to the client on how much is shared or what is shared. And it's a reminder of, I don't need to share everything with a community member, and the community member, as the friend of the survivor, doesn't need to share everything with me either. So really setting those boundaries and that role delegation is really important. This is not the first time you've heard about case manager notes or case notes, but we just wanted to reiterate that they should be all about service provision, so needs assessment, what need was identified, what steps were taken, and what goals were achieved. You don't need to say more than that. You can be very bland, so to speak, no information about their trafficking situation, and it's just a reminder that, you know, it's not just a criminal or civil case that could come up related to their trafficking. Here we're seeing such a large uptick in family law cases, so you have to think about more broadly of why or when could your case notes be subpoenaed, and so be really careful about what you're putting in case notes, and talk as a team what that looks like, and talk to your supervisor as well.
So our final poll question is, my agency has legal services for clients in-house. I do not have to refer out to another organization.
I'm sorry to interrupt. This is Amy. I just wanted to let everyone know that while you're participating in this final poll, we really only have a couple slides after this. So if you'd like to hang on with us past the allotted time, please do, but it's just a couple more minutes. And if not, obviously, feel free to get to your other work. Thanks.
So, great. It's great that 40% of you do, 60% of you don't. But it's important for those of you that do have it in-house that you, and we can go to the next slide, that for those of you that have these services in-house, that you also continue to follow these practices, that just because they're part of your organization, unless they are part of your legal team, and each state views that differently, that's really complex, we're not going to get into that, that you still need to be doing these releases of information, that your file systems need to be separate, that you're regularly going over the roles with your client and explaining to the client what each party knows, so that your client just doesn't assume that you're always cross-sharing information, because you're not. And I know that's really important when I'm making referrals to case managers, that my clients want to know that I'm not talking to them about their legal case, and that they can share information that has nothing to do with their legal case, and in no way would I ever need to know it, that their case managers aren't sharing that back to me. And so it's just important that if your agency has this, if you don't already have a system in place, you should work on it. It took our agency a year when we started our Victim Legal Assistant Network to make sure that our licensed counselors who are part of that program and underneath the legal aid were going to be covered and have separate confidentiality, and figuring out a best practice for that. Next slide.
So in sum, as Amy mentioned at the beginning, there's going to be a live chat in 2 weeks. So think about your questions, throw them into the chat box now, or you can email them later. But in between now and then, perhaps to kind of generate some questions, review your agency's confidentiality agreement. Are there things we said today that you were like, oh, we don't do that, or let's think about rephrasing ours? Review your release of information and discuss your confidentiality policies as a team, and let us know what comes up. Let us know if there are specific challenges you're seeing. We'd love to think through it with you in 2 weeks on the chat. So then I'll just hand it back to Amy to talk about wrap-up logistics.
Thank you very much. Thanks, Darcy, and thanks, Catherine, and thanks to all of you. Nobody dropped off, so we take that as a really good sign that this information was relevant and helpful. We want to remind everyone that the live chat will be happening in 2 weeks on the 25th of October. Please submit your questions in the chat box or through this email address, tictraining@freedomnetworkusa.org. And be mindful that there will be an evaluation sent, and we ask you to be honest, provide us with honest feedback. And with that, again, thank you to Catherine and Darcy, and we'll talk to everybody in 2 weeks. Have a great day. Thanks, everyone.